All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Y'all be seated. All right, so assume that y'all are ready still? Okay. Madam Clerk, if you want to call this case, please.
Case number SC 2024-0810, 790 Montclair, LLC, v. Birmingham Metro, LLC, the City of Birmingham, the station at Crestline Heights, LLC, Valley National Bank, Alabama Hoops, RE, LLC, FirstBank, Trinity Montclair 800, LLC, Trinity Montclair 820, LLC, and Birmingham Metro Baptist Association. Arguing for the appellant, the Honorable Diane Mon. And arguing for the appellees, the Honorable Harris Haygood.
Thank you, Chief Justice Stewart. Associate Justices, may it please the Court. Question presented in this case is whether the City of Birmingham Planning Commission's approval of a subdivision plat submitted by Birmingham Metro is invalid due to the failure to provide notice to 790 Montclair as an adjoining landowner of the subdivision hearing. Following this Court's precedent, the answer to that question is undeniably yes, and the approval of the subdivision plat is due to be invalidated. As a brief background, 790 Montclair purchased its property at issue in December 2018. Birmingham Metro purchased adjoining property in the spring of 2020, and in October of 2020 submitted an application to subdivide that property. A hearing on the subdivision application was held November of 2020, and the plat was approved on the same day as the hearing. It's undisputed that 790's parcel is adjacent.
So let me ask you this. If you had gotten notice, would you have opposed the subdivision plat?
790's position is that it was entitled to notice as a matter of due process and an opportunity to be heard and to voice any opinions, any objections, or even support for the subdivision as that matter. But it was entitled to the opportunity to be heard as to any potential concerns that it had about the subdivision plat.
Thank you.
This Court's decision in Kennan and Associates versus Gentry is on point and is controlling. In Kennan, property owners challenged the rezoning of an adjacent lot because procedural notice requirements were not followed and adjacent property owners were not mailed notice as was required by a local zoning ordinance. This Court conducted an extensive review of both subdivision and zoning authority regarding the consequences of the failure of the Municipal Planning Commission to comply with all procedural requirements. Those authorities included both subdivision and zoning cases reviewed by this Court, and it held that in the line of decisions discussed herein, where there had been a failure to strictly follow the procedural requirements applicable to the action sought, especially notice provisions, this Court has invalidated the ordinance passed or the action taken, irrespective of whether any person was prejudiced by the error or the omission. Notably, in the Kennan case, one of the adjoining landowners who was complaining was not provided notice by mail, but actually had actual notice, and the city of Phoenix City was another adjoining landowner that was not provided with notice by mail. And the Kennan argued that the city didn't have to provide notice to itself. This Court said, regardless, because of the procedural requirements that mandated that notice be mailed to adjoining landowners were not complied with, that the action taken was invalid. This precise issue was presented and addressed in an opinion by then Attorney General Bill Pryor in 2000, wherein he applied that Kennan decision to conclude that the action of a city planning commission in approving a subdivision plat without providing notice to adjoining landowners invalidated the approval of the subdivision plat.
All right, so let's say that we do that. We invalidate this.
Yes, Your Honor.
It goes back to the planning commission, correct?
Yes, Your Honor.
Okay, so if it goes back to the planning commission, what really changes? You have notice, they have a hearing. There's now a project that's, I forget how much it is, $50-60 million. So just
Correct.
you're willing to do this for that benefit?
Well, Your Honor, and according to Attorney General Pryor's opinion, that is the proper remedy, is for it to go back to the Planning Commission, for proper notice to be provided to all adjoining property owners, and for a new hearing to be held. And at that time, 790 and any other adjoining property owners can present to the Planning Commission their position about the subdivision. In this case, it's more than just the subdivision of parcels. It's the subdivision plat itself and certain easement, reciprocal easement provisions that were not included on the plat, and a restrictive covenant that was included on the plat, which we contend is inconsistent and contradictory to existing easements, which apply to both the platted land and 790's adjacent parcel.
So everybody agrees, though, whether something's on a subdivision plat or not, if it's recorded in the probate court, that easement is going to be effective, right?
That is true, Your Honor.
So what do you say about the trial judge's order granting summary judgment, Judge Huey's order in paragraph 3, where he says that there is no legally cognizable claim that the, I'll substitute here, subdivision plat has caused any injury, nor is there any dispute that such instrument is not subject to any prior recording documents that apply to real properties encompassed by those instruments. In other words, he's saying it's not legally cognizable because there's no injury. So how do you respond to Judge Huey's holding?
Justice Cook, I believe that holding and Judge Huey's order was really directed towards a claim that was in the plaintiff's complaint that requested a declaratory judgment that Judge Huey declare that the restrictive covenants that are on the plat do not trump or supersede the two reciprocal easement agreements that were left off of the plat. And I think in the defendant's response brief, they conceded that that was what that language in the order was directed to that claim and not to 790's claim seeking to invalidate the plat due to lack of notice.
So since we all agree that these other easements that were left off the subdivision plat are still effective, why is there anything left for us to decide?
Because in this case, the point is that 790's due process rights have been violated. Its right to notice and an opportunity to be heard at the subdivision hearing, and to hold otherwise would be directly contrary to this court's precedent, including Kennan, which said that it's irrespective of whether there's any prejudice shown to the party that didn't receive notice. The action taken without providing notice to the adjoining landowner has to be declared invalid due to the failure to follow the procedural requirements.
So let me change topics a little bit. I'm trying to understand how this happened. I've looked pretty deeply in the record. I don't have even a theory for how this happened. So do you have any theories as to how it was that this notice was not provided?
Well, you're right. There is no evidence in the record as to why 790 Montclair was not provided with notice of the subdivision hearing, or why their name was not included on the list of adjacent properties that was submitted to the Planning Commission. As the evidence demonstrated, which we submitted with the trial court, the Jefferson County Tax Assessor's records clearly have 790 Montclair's name and address in the records of the tax assessor.
Wait, I'm going to ask about that. So I've got a document here. It's 959, and it's a screen print from the Jefferson County parcel lookup that looks like it's the GIS mapping system that the county tax assessor has. Have you seen that page?
I've seen that page, yes, sir.
In fact, I think you have a screen print of that page in your brief, your reply brief, right?
I did include part of that in our reply brief, along with the record evidence from the tax assessor's office that shows 790's name and address in the tax assessor's record.
And as I understand it, nowadays, we're in electronic world. Nowadays, the GIS mapping system is the platting system that the tax assessor uses, right?
I don't know the answer to that. I mean, I believe that it may be one tool that the tax assessor's office uses.
It's the only plat they got in the tax assessor's office now, right? Is the GIS mapping system.
That may be true.
So looking at this one, again, the same screenshot as in your brief, it's got the owner's name and a colon, and then it's blank.
That's correct.
So the plat, the mapping system that the tax assessor has, does not have the owner's name for this parcel.
I don't think that's true because the tax assessor's records that we at 790 Montclair obtained and attached to its affidavit evidence, which it submitted to the trial court, showed that it obtained that the records in the tax assessor's office show 790 Montclair as the owner of that parcel and show its address in the records. That GIS map that you're referring to was not submitted to the trial court with any affidavit or deposition testimony. It was submitted attached to defendant's brief so there's no evidence as to where it came from, when it was obtained, whether that same information was available at the time.
Do you dispute that this is what the GIS mapping system for the tax assessor says?
I dispute that that's what it currently says. And I don't know what it said in 2020 because of that document. There's no evidence that it was obtained in 2020. Also, Your Honor, if you look on that GIS mapping document, you can see there's a hyperlink that says click here for more property information. And we don't know, based on the record evidence, if you click on that, whether it would show 790 Montclair's name. But we do know that 790 Montclair's name is in the tax assessor's records based on the record summary that we obtained and submitted to the trial court.
So we're at the summary judgment phase. And so is this issue then the material fact that we should send it back for the court to determine whether or not that they had the ability to know who should have gotten notice? I mean, is that enough of a fact that's in dispute that we could do that to reverse the trial court?
No, Your Honor, I do not believe there is a substantial dispute of material fact based on a few things. The information that we submitted from the tax assessor's office conclusively establishes that the information is there. The name and address for this parcel are in the tax assessor's office. That's irrefutable. Now, and again, there's no record evidence of what was done to try to find 790's name and address in conjunction with the subdivision application. But even if another database was consulted that had incomplete information and only had the address, that doesn't refute the fact that the name and address information are indisputably in the tax assessor's records. We pulled them up. We attached them to the summary judgment filing with an affidavit again. Furthermore, even the document submitted by the defendants, that Jefferson County parcel lookup, has 790 Montclair's address on it. Therefore, even if that was the only information that was obtained in searching for information to provide notice to adjacent landowners, it had the proper address to send notice to 790 Montclair and should have done so in conjunction with the subdivision hearing.
So I'm a textualist. Some people think I'm too literally a textualist sometimes. The statute here, which is 1152:32, says similar notice shall be mailed to the owners of the land immediately adjoining the platted land as their names appear upon the plats in the county tax assessor's office, and their addresses appear in the directory of municipal or on the tax records of the municipality or county. So as I read that, the names appear upon the plats. And if the GIS system is the plats, there is no name on the plat.
Your Honor, the Birmingham Subdivision Commission was required to comply with both that statute and the subdivision regulations that it passed pursuant to the enabling statutes. And this court has held that regulations so passed are binding and given just as much effect as a statute. And therefore, the subdivision regulations state it a little bit differently. They say that notices to be provided to landowners as their names and addresses are shown in the tax assessor's record.
It does, and it's broader. You're absolutely right. I guess when I'm struggling with, I got a statute here, and normally the regulation can't go further than the statute.
I believe in this case it can. If you look at the Kennan case, there was a statute that provided for published notice of zoning changes, but the local zoning ordinance also required individual notice be mailed to adjacent landowners. And so the city had to comply with both of those requirements. It had to do the published notice and the individual notice. Your Honor, may I finish my answer? And so in that case, this court held that the failure to comply with both the statute and the requirements of the local ordinance invalidated the action taken because the local requirements were not complied with.
And that's the Kennan case?
Yes, Your Honor.
Thank you.
Thank you, Ms. Vaughn. Mr. Egan?
Thank you, Your Honor. May it please the court. My name is Harris Haygood, and I represent Birmingham Metro LLC, one of the appellees in this matter. And Your Honors, I'll jump straight to the point. Justice Cook, you're correct. And all of your questions, you're hitting the nail on the head. I do have a theory about how all this happened, and I do not believe that Kennan should be expanded into the subdivision regulation realm. Kennan was specifically addressed to the zoning ordinances and not to subdivision regulations.
So what is the difference? I mean, is zoning a higher level of regulation? So due process is more important because we're rezoning property, and maybe due process isn't as critical when we're doing subdivision plats?
That's correct, Your Honor. That's our interpretation. Our position is that zoning affects more than just the parcel itself. It affects your neighbors and adjoining landowners much more significantly. That's why zoning requires public notice and mailing notice to adjacent owners, not just mailing notice to adjacent owners.
So we can distinguish Kennan then because it involved zoning and not subdivision plats?
Yes, Your Honor. And this court has held that planning and zoning are two separate divisions of law. Subdivision law and zoning are not the same thing. So you could distinguish it based on that. And in terms of Kennan, I guess we'll start with Kennan. Yeah, the court held that strict compliance is required, but it also this court cited to other secondary sources that said when statutory notice is mandatory, substantial failure to comply will invalidate the action taken. So while strict compliance is the standard of this court, it's also realized that substantial compliance can a lot of times make up for that strict compliance requirement, or at least just acknowledge that. And in this case, even if Kennan were to be applied to subdivision regulations, our position is that we complied with the statute. We provided notice to adjacent landowners as shown in the tax assessor records. And as Justice Cook pointed out, when you pull up their parcel on the Jefferson County GIS map, it was blank up until a few months ago. I pulled it up last night, actually, and now it does populate with 790 Montclair LLC's name. And
but the question is, did it look like that in 2018?
Yes, yes, Your Honor, it did. It looked like that in 2022 when it was filed, or 2023 when it was filed, and it looked like that in 2020. According to information from Shoal Engineering, who prepared the application, prepared the plat, submitted it to the city of Birmingham, and attended the hearing.
And was that evidence presented at trial?
Not testimonial evidence, no, Your Honor. There's just this GIS map that has a blank, and I can represent to Your Honor that 790 produced tax assessor records that does have their name and information. But the only way you can get to that is if you know 790 Montclair's name. If you go onto the Citizen Access portal and you search 790 Montclair Road with or without road under the property address section, you get no results. If you search mailing address for 790 Montclair, you get 300 results. So it's impossible to determine from either the plat or the tax assessor records who that owner is. And that's what's
So-
required by this.
You say the only way you can get there is to know the name. What evidence do we have of that?
There is not any evidence of that in the record, Your Honor. That is, I guess, based off of my own independent look and the discussions with Shoal. So there is no record evidence of that. That being the only way you can get to it. The evidence is that,
Look at that. I mean, if it's not in the record, we can't.
right, Your Honor. What is in the record, though, is that Shoal submitted an application that adjacent property owner information was sent out. I think the record citation for that is, let's see.
We know
It was,
we know
yeah, it was 874 is where that list of adjacent owners were sent out to,
But it
I
wasn't
think
sent.
3 or 4, but 790, it's undisputed, was not included in that record. And the other evidence is that the notices were sent out. Shoal testified in its deposition. Mr. Brittner testified that Shoal has a standard operating procedure that they go through when submitting subdivision applications. They check 3 different sources, one being what is akin to the Jefferson County GIS parcel lookup, and the others being, I guess, various sources that they can look to if that source does not provide detailed records of the ownership information. So the logical conclusion there is that there was no information for 790 when it submitted its application to the city of Birmingham for approval. The city noticed the hearing, the plat was approved and recorded. And
So any theories on why this was missing from the GIS?
Mr. Meadow, the corporate representative.
That's not in the record. I don't know that we can
Yeah.
get to that.
No theory. Well, I've got a theory, but Mr. Meadow testified that he personally did not update Jefferson County's tax assessor records after closing. He assumed that it was part of the closing that it would be handled.
So who is that?
Mr. Meadow, 790's corporate representative, testified to that in his deposition, which the transcript is in the record.
And he testified what again?
He said that he did not personally update the tax records with Jefferson County after he closed on the property, or 790 closed on the property in 2018. He assumed that it was part of the closing deal.
So so there's no question that 790 did not get notice. Is there any dispute about that?
No, Your Honor, there's no
But
dispute.
what we're saying is maybe there's an excuse of why they didn't get notice. And the trial court considered that in granting summary judgment.
Yes, Your Honor. And the trial court actually, during the hearing, pulled up Jefferson County records and looked at where the parcel ID information was blank. That's in the record as well. Judge Huey pulled it up and acknowledged that that parcel map did not include any information. Now, if you go into it, like I said, it does populate. So what we have in terms of, I guess, preserving that is the screenshots, which obviously is not
So if we're going
evidence.
to look at what the statute says, and the statute says you've got to give notice, and obviously you're doing something that's going to affect people and their rights to property and that sort of thing. So notice is required, but there's an excuse if we can't get notice, either the property address is wrong. So help us go over that hurdle of the statute requiring notice, due process requires notice. How do we get there based on this situation so that we can affirm? I assume you want us to affirm the summary judgment.
Yes, Your Honor, easily enough. The statute, like Justice Cook pointed out, says that you provide notice to adjacent landowners as their names and addresses are shown on the plats and records of the county. Birmingham or Jefferson County subdivision regulations require that you provide notice to adjacent owners with names and addresses as shown in the county's tax assessor records. So if the names and addresses are not shown in the county tax assessor records, then the notice, the requirement to take any further steps is eliminated by this regulation itself. If those names and addresses are not there, then you move on and the city provides its notices. And that's if you give a strict compliance interpretation and take Kennan into the subdivision realm. Yeah,
How do you get to the trial court saying there's no justiciable controversy?
Yes, Your Honor, that's a greater and even better question because there is no injury here. What Judge Huey found is that even if they didn't receive notice, and even if all their other allegations that they claim against this plat were taken into consideration, that they still have no harm. They have no concrete injury that's redressable by this court, either through a declaratory relief or otherwise. 790 Montclair could not point to any real injury that it has suffered. And while this court in Kennan did not, that prejudice is not a consideration when considering strict compliance requirement, in this case, there has been no prejudice. No property rights have been revoked, removed, altered, amended, and there's been no damage to 790 Montclair. What they are seeking to prevent, and I think it was testified to and it was discussed in the summary judgment hearing, is that there could be potential litigation involving this plat concerning a new declaration that was referenced in it and the lack of the easements being depicted on the plat. That's a forward-looking harm that is not imminent or concrete, and there was no injury, and Judge Huey properly found that.
Just out of curiosity, and again, it's not, have y'all tried to mediate this case or come together and try to figure this out before it rose to this level?
Numerous times, Your Honor. We've attempted to resolve it numerous times. I think there's been 2 mediations.
Mr. Haygood, you can move on to
Go on.
Your Honor, I'm sorry.
You can just go ahead and move on to your substance of your argument.
Okay. The other evidence of lack of injury is that they say that, Justice Cook, I think you asked the question of what would they have done if they had gotten notice? Well, I think the evidence and the record is clear that they wouldn't have done anything other than what they did. They did not attend the zoning hearing that rezoned the entire parcel, which was noticed. And
So in zoning situations, there's usually a sign that's put around the property to give kind of constructive notice.
Mm-hmm.
So that's zoning. We've got a subdivision issue where signs put around to give adjoining property owners constructive notice.
That's a very good question, Your Honor. Judge Huey asked me the same question, and no, the answer to that is no.
So they wouldn't have been any kind of would anything have given them knowledge other than actual notice that this was going to happen to this property the subdivision plat was going to be recorded as it was approved?
That's a good question, Your Honor. I don't believe that anything else that any other actions taken would have given them notice.
So is notice then, notice seems that it should be absolute because we're affecting people's rights. So we're trying to find, if we're going to do what you want us to do, some exceptions maybe that if notice isn't provided, then maybe there's some way they could have protected their rights. And it seems like you're saying as well, there weren't any rights to really protect. And so if we don't have rights to protect, then notice doesn't matter.
In this particular instance, there weren't any rights to protect, or they wouldn't have taken any steps that they didn't otherwise take. But I guess in terms of constructive notice, that requirement is in the zoning regulations, but it's not within the subdivision regulations. So I guess if the legislator wants to make sure that everybody's notified, they could modify.
Did the zoning come before the subdivision hearing?
Yes, sir. It did, Your Honor.
And did they get actual notice of the zoning?
The actual notice of the zoning, no. I don't believe so.
Was that required?
The same issue occurred in the zoning as did in the subdivision. That parcel information for 790 was blank in the adjacent landowner, but they did post notices and advertised it and things of that nature.
Why aren't they complaining about not getting notice in the zoning case too?
So another great question, Your Honor, that I think might be better answered by them. But They have not complained about the zoning.
Does the Planning Commission have a public posting of their agenda?
Yes, Your
What they're
Honor.
going to be hearing? Could that be considered constructive notice?
It would certainly be notice to the public of their upcoming agenda and what's scheduled to be heard on particular hearing dates. And I think they hold one hearing a month and publish that agenda in advance. In fact, the notice that went out says you can see the agenda using this web link. So,
I take it y'all didn't argue that. That wasn't argued.
no, Your Honor.
Thank you.
There were several news stories about this development, right?
Many, Your Honor. Yes, sir.
Before or after the subdivision hearing?
I believe leading up to, before, and subsequently. So there were several news articles about Birmingham Metro, my client, purchasing the property from Baptist. There were several news articles about the station's development and its plan for the property that it purchased. So there, at least
That
5 or 6.
constitute constructive notice at all? I mean, is there any argument for that these news stories or whatever create some general knowledge that something's going on, and so I need to check on my rights, and so therefore I've been some form of constructive notice that could be held against me because I didn't show up at the Planning Commission?
Candidly, honored to agree with you. Yes, I would love that to be the case. I don't know.
There's no law that
I
supports
don't have any
this.
basis on law to support that, and I've tried to find constructive. But our position is that if strict notice is required, then strict notice to adjacent landowners as their names and addresses appear on the records or the plats as the statute requires is the obligation, and it's not as broad as what the, say, zoning regulation in Kennan said, which just stopped at adjoining owners. It required the building commission to provide notice to adjoining landowners, period. It was an unqualified obligation of the city at that point. And that's another distinction, is that the city had the obligation there to notify adjacent landowners, and it wasn't, the onus or burden wasn't put on the applicant to submit that list. So a distinguishing factor there that makes this case a little bit different from Kennan. And the Attorney General opinion issued, basically, we say that it's not persuasive in this matter, because in that case, there is no discussion of what the city's regulation required or what notices may or may not have gone out. It just said 3 adjacent landowners were not given notice, therefore it's invalid and has to go back to the Planning Commission for consideration. I think Justice Sellers, I think you asked about the lack of records giving enough for a dispute of fact that this court could overturn. I guess lack of notice records or lack of records with respect to the Jefferson County GIS mapping system, and testimony on that point. We do not believe that it would create enough disputed fact, primarily going back to the redressability or the justiciable controversy element here, is that there has been no injury. There's been no concrete harm that's imminent that gives this court or the trial court a right to redress anything other than a validly approved subdivision plat that has not affected or harmed or damaged 790 in any way. Therefore, we would ask that the court uphold the trial court's decision. Any further questions, Your Honor? I know I finished a little early, but I'll be happy to answer any more.
Timing-wise, when was the subdivision hearing?
The subdivision hearing was held, I believe, November 14th of 2020, which...
And you started site prep work in late 22?
So my client...
21, sorry.
...is the owner of the entire parcel, but the station did start site prep work, and I think it was... they purchased it in March of 21, and so it would have been after that. So yes, sir.
And the first objection was the summer of 22, so
That-
7 or 8 months later.
That's correct. 7, 8 months. August of 22 was when the injunctive proceeding was filed. And Your Honors, you have to keep in mind too, this is 2020. So COVID was very, very prevalent during this time period. So the ability for Scholl to just go down to, again, this isn't not in the record, but the ability for Scholl to go down to the office and pull up records was not there. All they had was the online system. So
When they had the zoning hearing, was the whole plan presented to the zoning commission?
yes, Your Honor.
So it wouldn't have been the presentation wouldn't have been any different to the subdivision committee and the zoning committee.
Would have been narrowed and hyper-focused just on those 3 lots that
It would have been
being
a sub part of what.
That's right. That's correct, Your Honor. It wouldn't have encompassed all of what zoning did because zoning was concerning changing the entire Baptist property. In this instance, it was just the subdivision of 3 parcels within the larger parcel.
But 790 did not receive notice of the zoning either.
It's not in the record, but I do not believe so. Thank you, Your Honors.
Thank you, Mr. Hagood.
Thank you.
Small.
Thank you. To address a few of the questions that were asked to Mr. Haygood, with respect to the Kennan decision, that case, the court specifically relied on both subdivision and zoning cases in deciding that the failure to comply with procedural requirements invalidates the action taken. And this court has, in other cases, stated that both subdivision and zoning are part of planning, and they're both require that procedural requirements be satisfied with respect to each. So Kennan cannot be distinguished on the fact that it was a zoning case as opposed to a subdivision case. I think Mr. Haygood mentioned something about substantial compliance with the notice requirement was sufficient. This court has said in ex parte Bedingfield that that is not true, that substantial compliance is not sufficient based on the Kennan decision. This court reversed a Court of Civil Appeals decision that did apply substantial compliance, and this court said, no, that is not sufficient. Regarding how you can obtain the information that was submitted with 790's affidavit testimony that was pulled from the tax assessor's online records, it is not correct that you can only get that information by putting in 790's name. If you put in the parcel number for the property, you will pull up the name and address for 790 Montclair. And I would think that Scholl Engineering, as a surveying company that's submitting a subdivision application, would be able to find the parcel number for an adjoining property and pull up the information showing the name and address of that property owner. Mr. Meadow testified in his deposition, and this is in the clerk's record at 1586. He said that either 790 updated the tax assessor's office with the correct owner and address, or its closing attorney did it. So once 790 bought the property in 2018, the name and address information was updated. The affidavit testimony was that 790 received its tax assessment notices from the tax assessor every year since it bought the property in 2018. And so, like I said, the records themselves demonstrate the name and address of 790 in the records of the tax assessor's office. Therefore, they were there to be found.
So let me ask you about the zoning question that I asked other counsel. Why are you not complaining about the lack of notice for the zoning commission hearing?
Well, Your Honor, the issue in this case was about the failure to provide notice of the subdivision hearing. Frankly, I'm not sure whether the local zoning ordinance required individual notice to 790 or not. I do know that it would require published notice. To my understanding, that was provided, but that's really not a part of the record in this case. The concern in this case was the failure to provide notice of the subdivision hearing based on the fact that 790 is an adjoining landowner. It was entitled to mailed notice directly to 790, and it didn't have the opportunity to go to the subdivision committee meeting to talk about the restrictive covenants that were placed on the plat in the absence of the reciprocal easement agreements that were not included on the plat that had been included on previous versions of plats of this property. That's why the
Does the recorded plat mean anything at all? That weren't got given notice, everybody seems to agree with that, but you do have a plat that gets recorded. So does that mean anything at all? Does that have any value whatsoever, or just is simply going to be disregarded if we were to reverse?
If I'm understanding your question, I think that, that the recorded plat itself would need to be, there would need to be a notation in the public records that that plat is invalid if the subdivision committee holds a new hearing and gives proper notice to all adjoining landowners and then approves a similar plat or maybe a slightly different plat, maybe a new plat that includes references to the reciprocal easement agreements. Then that new plat would be recorded and would supersede the prior plat.
But in this interim time, there has been a plat. It's been recorded. It seems like to me that there have been actions taken consistent with the plat being recorded and providing different things. So how do you suggest that the court unwind that, or it just doesn't matter? We didn't get notice. We stopped the analysis there. No notice given. It's invalid. It goes back to the planning commission. But you've got something that's happened in this interim period of time. So how do we deal with those things that went on in reliance on a plat? Because if I'm a stranger to it, I see a recorded plat. I don't know all this background. I take actions consistent with it. Now I've developed some property rights. If we send it back, how do we deal with those affected rights?
Well, and that can be addressed by this court's early decision in Thomas versus Cowan. I think it was back in 1906, perhaps. But that case addressed a predecessor statute to Alabama Code 11-52-33. That statute is in place and provides that if a landowner sells property in reference to a subdivision plat prior to it being approved and recorded, then that subdivider is subject to a penalty. However, the Thomas versus Cowan case said that any innocent purchasers of property pursuant thereto are not thereby penalized. There's no effect on the transfer of the property to those innocent purchasers. So those transfers and conveyances are not voided. There's no effect on people who have purchased property subject to the plat, even if it's declared to be invalid.
So if it's invalid, but you've got people that are innocent purchasers, I believe that's in the record. They've done things consistent with the plat because they don't know any of the background. They see a recorded plat. Nobody knows to say, well, do we have to double check? There's no litigation. Maybe a good abstractor would do that, but they don't know that. So now we're going to invalidate a plat that people have relied on. We're going to have two competing plats at some point, wouldn't we?
Chief Justice Stewart, may I respond? I think that there would be a way to record in the probate court records an indication that the 2020 plat has been invalidated and that it has been superseded and replaced by a new plat, assuming that one is properly approved.
Thank you.
Thank you.
Hang on, Ms. Vermont.
I wanted your
has a question.
sorry.
Oh.
I want your response to my question that I gave opposing counsel about the justiciable controversy.
Yes, Your Honor. And I think that the justiciable controversy, again, I believe that ruling by Judge Huey was directed to a different issue than the one that's on appeal here, and I believe that defendants conceded that in their response brief. But the law is clear that based on Kennan and other cases, including Ex parte Buck, that a adjoining property owner who did not receive notice of a subdivision hearing does not have to prove prejudice thereby. And that's what the Kennan court said. It doesn't matter if there was no prejudice. That case, the party that didn't receive the mailed notice did have actual notice, but this court held that it was still, the action that was taken was still held invalid. Therefore, it wasn't required to show prejudice. There is a justiciable controversy whenever any party seeks to bring an action to have the rights declared with respect to actions taken by a municipal body that were done in violation of the procedural requirements that govern those actions.
Thank you.
Thank you.
All right, we will adjourn. Thank you all very much for your time.
All rise. Court is adjourned.